All right, welcome back, everyone. My name is Amanda Tyler. I am privileged to hold the Shannon Cecil Turner Professor of Law Chair at the University of California, Berkeley School of Law. You might have heard of it. It's a little school across the bay that has a small rivalry with another school where we may or may not be right now. I'm really thrilled to be here. It's always a privilege to come back and participate in events here organized by Michael and Morgan, and I just want to thank the two of you for inviting me, putting on this yet another great event, and everyone else who has helped organize this great conference. Our panel is on internal executive branch resistance, a really important and very timely topic, and we have four extraordinarily talented and great commentators to launch our discussion. I am going to buck the trend and introduce them each individually as they speak, because I want to be a little different from my predecessors. And so we're going to go, I think we're not quite sitting in order of how we're going to proceed, but we'll start first with Santiago Perez, who holds a PhD in economics from this wonderful university and is currently an associate professor of economics at UC Davis and a research associate at the National Bureau of Economic Research. His research is in the intersection of economic history and applied microeconomics. So without further ado, I turn it over to you. Yeah, and he's going to come up here.
All right, so thank you so much. So I'm probably the only non-lawyer giving a talk, and that's why I have slides, so I apologize for that. So I'm going to be talking about some research that I've done with a co-author at UC Davis, and probably a bit of an overview of that. Some research where we try to investigate the consequences of what we see as a really major reform in American history, which is the so-called Civil Service Reform Act, or Pendleton Act, as it's commonly known as today. So let me give you a bit of a very bird's-eye view of the American of the civil service reform. So prior to the Pendleton Act, we lived in this spoil systems era where appointment to office is basically based on who who owes you a favor rather than on fitness for office. And now in the 1860s, there is this push to reform the American civil service, which is partly inspired by earlier reforms that took place in Europe. The exact timing of the reform, why does this pass in 1883? It's related to two sort of idiosyncratic events. So the first one is that James Garfield is going to be shot by a disappointed office seeker, someone trying to get one of these patronage appointments. And second is that the Republicans are going to be defeated in the midterm elections of 1882 and anticipated that some of their office holders might lose their jobs. They rushed to pass the reform. So, some nice cartoon, basically illustrating this, how really civil service reform is at the center of this, high-profile killing, and how this sort of creates the right political environment for passing the reform. So what did this law do? So the law is in a way not very ambitious in terms of what it's trying to what ends up doing in practice. So, and it's limited in two ways. So first is that it's only going to affect how people enter the civil service. It's not going to have much bite in terms of what happens after people have been hired. So it's not going to give tenure to employees. It's not going to, at least initially, regulate how promotions are going to happen within the civil service. And the second reason why this is sort of somewhat limited reform is that it's not going to affect the entirety of the civil service, but rather it's only going to affect what we call the classified civil service. And there's going to be three branches of the civil service which are affected. The first one being the customs service, and within the customs service, this is going to be limited to custom districts with 50 or more employees, and within this district to workers making $900 or more. This seems like a detail, but we're going to argue it's going to be crucial in understanding some of the impacts that this law had. The postal service, and here it's also going to be limited to offices with 50 or more employees. And the classified departmental service, people working in Washington, D.C., and here this is going to be limited to people in these more clerical and technical positions making between $900 and $1,800 a year. So basically what this law is going to do basically is to introduce the civil service exams, which are, unlike other civil service exams in history, not trying to test the knowledge of this very high-level content. It's really going to be a content that this is kind of an American exceptionalism in this regard, content that people would, in principle, should have learned in elementary school. It's going to be about arithmetics, writing, and reading. So there's been quite a bit of an explosion of studies trying to understand what were the consequences of these reforms. A paper by Aneja and Zhu looking at what happened in the postal service, a paper of mine and my co-author Diana Moreira, also at UC Davis, looking at what happens in the customs service. And finally, a paper which tackles a bit of a slightly different question, which is also by me and my colleague Diana, where we look at the equity consequences of this reform and how did this reform shape the socioeconomic composition of the federal bureaucracy, tying this to some kind of very recent debates on the role that standardized exams might have in shaping who makes it in a particular organization. So all these studies are really based on a lot of newly digitized data, and in particular I want to highlight sort of personal records that we have been putting together over the last few years, where we were basically able to collect data on everyone who is working for the US federal government over a period of 20 years, then match some of these people to a US population census and learn about their social, family background, professional background, etc. So what do these studies find? So first is that the law seems to be successful in achieving its more kind of obvious goals. So first, we document a reduction in what we call politically motivated turnover. So we see that after the reform, people that are in these classified positions are more likely to stay longer term, and particularly these effects are more prominent when the federal government changes party hands. We are also going to document that there is an improvement in the professional background of workers. So we see that these people, prior to joining the civil service, are more likely to have the types of occupation that you would expect for a bureaucrat. They're more likely to be lawyers, accountants, etc. Now, when we look at performance, the picture is a bit more nuanced. So in our study looking at the customs service, we're not going to find much of an efficiency improvement, where we measure efficiency looking at how much each customs collection district is collecting in relationship to how much they are spending to collect that revenue. Whereas when Aneja and Zhu look at the postal service, they do find that this leads to more efficiency, which they measure based on delivery errors, mail delivery errors. Now, we want to argue that one potential reason for this difference between the custom and the postal service is related to the design of the reform, to some of the details of the reform, where basically we argue that the rules in the customs service are much easier to elude, given that workers that make less than $900 are going to be exempted. And I'm going to show you that there is an explosion of people making exactly right below the cutoff. So, I'm only going to show two figures, but I think this one is pretty easy to understand. So we have the non-classified districts are the ones who are not subject to the reform, the ones that have fewer than 50 employees. The classified districts in orange are the ones who are going to be subject to the reform. And here what I plot is employee turnover. So what's the likelihood that an employee would leave the organization within a 2-year period? And we see that prior to the Pendleton Act, the orange dots and the blue dots are pretty close to each other, meaning that turnover is pretty comparable in these two types of districts. But after the reform, the blue dots and the orange dots become really far apart. And particularly, they are really far apart whenever there is a change in the party identity of the president. So basically, following the act, we see these big gaps between the classified and non-classified districts in terms of turnover, indicating that basically the districts that are subject to these regulations are much less likely to experience these politically motivated turnovers. Now, when we see who these people are hiding, we see that these classified districts, which are the ones that are subject to the reform, see a very sharp rise in the proportion of people who make a little bit less than $900, which is consistent with this idea that these districts are trying to retain discretion by exploiting this sort of loophole in the law that allow them to hire people right below this cutoff without going through the trouble of doing exams. Now we also, beyond performance, we look at other aspects of this reform in this paper, and we see that this reform also led to a change in the socioeconomic mix of government employees. We see fewer immigrant workers, fewer children of immigrants, fewer children of professionals, more children of professionals, fewer children of blue-collar workers, children from wealthier families. So overall, some indication that the reform changed the socioeconomic profile of government bureaucrats and made them a little bit more, to come from relatively more privileged backgrounds. So this is kind of, we interpret this through the lens of, in light of the previous result, that there might be some sort of equity efficiency trade-off where you are sort of trading off a more qualified workforce, and this is coming at the expense of having a set of people who are perhaps a little bit less representative of the American people. I want to conclude by saying that this research shows a bit of a nuanced picture of the consequences of the act, where there are some effects that happen which are perhaps what we would have expected, some more perhaps unintended effects of the reform. And maybe a broader lesson is that these reforms are obviously not implemented in a vacuum, and that incumbent agents are going to try to overcome some of the regulations, are going to react to those, and it's important to keep those in mind when designing such a reform. So that's all I have to say, and thank you so much for your attention.
So now that we have a sense of who's serving in the bureaucracy and how some of these reforms in the past have worked, we're going to talk more about what's happening within the executive branch internally. And to start us off, we're going to hear from Chris Walker. He is a law professor at the University of Michigan Law School and previously taught for about a decade at Ohio State. He's the former chair of the ABA section of Administrative Law and Regulatory Practice, and he's a senior fellow at the Administrative Conference of the United States. Over the last few years, he and Aaron Nielsen have been working and writing about how Congress and the executive branch can respond to the Supreme Court's increasing unitary executive turn in order to preserve a measure of decisional independence in federal agencies. Take it away, Chris.
Awesome. Thanks, Amanda. But this is really fun. So I want to start during COVID, Michael invited me to present a paper that at a virtual conference like this, where it's turned into a book project. And I want to just kind of talk a little bit about how that fits in with the Federal Civil Service. But before I do that, I just want to pause and say, I was just thinking about this morning, that the impact Michael McConnell's had on the field of law. I was thinking of all the different books and articles that have been produced by the conferences he's put on, all of the amazing fellows that have come out of his center, and just the impact. And it's one of those that I just think is just really, really special. I've only had a little bit of that, but I think this book project wouldn't have actually come to be if I hadn't, during COVID, tried to workshop an early draft of an essay and got the feedback that I probably needed to blow it up a little bit bigger. So in this book, I argue that administrative law as a field fixates way, way, way too much on courts, and that the vast majority of agency actions today never make it to court, whether that's mass adjudications, where the courts only see the tip of the iceberg, a couple hundred of thousands of cases of the millions and millions that are decided each year, or if it's about enforcement discretion decisions that aren't reviewable by courts, or about informal adjudication decisions, like the decision to deport someone at the border before they can even get to an immigration court, much less an Article III court. And so in the first half of the book, I kind of outline and categorize and illustrate the various ways in which administrative law bureaucracy doesn't make it to court. And then the second half of the book, I explain what we can do about it. So I've got a chapter on Congress, I've got a chapter on the president, a chapter on the agencies themselves. But the very last chapter of the book, which I don't know how to write yet, and maybe I'll figure it out here, is I think ultimately, if what we care about is liberty and the rule of law and administrative law, that a professionalized civil service is a central feature of that. And preserving a professionalized civil service is going to be critical to respond to this phenomenon of bureaucracy beyond just review, of all these decisions that never make it to courts. And I say professionalized because I think that's doing a lot of work here. When we think about a professionalized civil service, we think about a group that is hired based on merit, that has a level of academic freedom, maybe one way to think of it, to speak their mind, and that also may have the idea that they're charged to say what the law is and not what it should be, that they're there, they're a professionalized group that's supposed to be implementing the law that Congress gave them under the political supervision of the agency head and ultimately the president. And the way you get a professionalized civil service, and you saw this a little bit with Santiago, is you have to create a culture. It's a set of norms. You have to hire based on merit and not on spoils or politics. You have to provide a level of tenure protection so that those individuals can feel like they can speak their mind and do their job well, and also so that, quite frankly, it makes the job more professional, more attractive to those that might have that. Yeah, my mic's doing weird stuff. And you have to pay them, and you have to kind of figure out how to develop that culture. And I think that in a world where most administrative actions don't make it to court, the bulwark of liberty is really going to be that professional civil service. Those are going to be the folks that remain in place to make sure that the administrative state doesn't affect individuals in ways that Congress does not want them to be affected. Now, of course, we've got a lot of academics in the room, and we know a lot of us have tenure or are going to be striving for tenure. And there are goods and bads on tenure, right? I mean, it's not all good. Sometimes that means you can't.
It's pretty good.
Well, I mean, so yeah, you're like, don't do it. Matt is like, don't do it, Chris, don't do it. Sometimes that means you can't get rid of people who are not doing their job well, or stop producing at all, or teach very poorly. You know, there are some costs. You also get people who let their politics lead their scholarship, or I think in more circumstances, you get people who are mission-driven and let their mission drive their scholarship, but maybe not facts and science. So I think there are costs. And those same costs apply to the federal civil service as well. I mean, I'm not going to deny that, but so there are the costs. The benefits are, hopefully have a professionalized group of individuals that are trying to faithfully execute their duties and protect the individuals in the process from overreach. But you also have that. And so that kind of leads to what we're talking about on this panel, this idea of bureaucratic resistance. And in law, at least, bureaucratic resistance, or the deep state, or however we want to define it, is highly under-theorized. I mean, Beck's written a great article. Jennifer No has started to kind of write a couple articles. But we really haven't really grappled with what that actually means. And I want to kind of try to divide out what it means and what it doesn't mean. And I'm going to do a really poor job at this. So at some point, Amanda's going to say, just stop. But so I think when we're thinking about it, I think there's lawful channels of bureaucratic resistance. Lawful by the sense that Congress by statute has created a whistleblower approach, or an agency has allowed for a dissent channel, or there's an inspector general that can report and investigate. That there are lawful channels in which civil servants can report abuses or potential abuses at their agencies, that they're guaranteed, they're allowed to by law. And on the other hand, you have kind of the alt accounts, like the unlawful bureaucratic resistance, where individuals are purposely not doing their job, or purposely violating a directive from a superior, or purposely not following the statutory mandate. And I think between that is where most of the action is, and I think it's the hardest part to figure out, kind of that gray zone of things that aren't necessarily clearly unlawful, but also not lawful. This might be as kind of Jennifer No says, going very slowly, or not kind of reporting in, or not signing briefs, or not doing this or that. And I think that's the category I think that's hard to kind of figure out how to address it and what to do with it and the like. And I kind of think of it, I'm on an HOA board now, and we were adding speed bumps to our neighborhood. We have 10, but they want to do 30. And I said, at some point, and our neighborhood's not that big, it's 2 miles of road, right? I was like, at some point, you're not going to be able to drive through the neighborhood at all. And they said, well, that's the point. I'm like, okay, that's bureaucratic resistance. That's a problem, right? So I think there's that kind of tension here that we have. Now, this isn't just a theoretical debate. The Trump administration took it head on and tried to do a lot to kind of deprofessionalize the civil service, whether that's through breaking up the unions or moving people to Schedule F, or we can kind of talk through more of that in the Q&A. And the Supreme Court has increasingly embraced a kind of an executive unitary approach that I think at least could reach at least the senior executive service of the civil service, those that have kind of higher making policy. And so we are going to have to confront this. And my main point with my opening is kind of my pitch to all my libertarian friends out there that see the civil service as an enemy, that I really think you're messing up, that you're not seeing this well. A professionalized civil service is what's going to protect you and the people you represent and the people that you're litigating on behalf of from government overreach. And the real debate should be is how do we keep them professional? And I think that's something we'll probably talk about more in the panel. So I'll stop there.
Thank you. That was great, Chris. I'm jotting down lots and lots of questions as we go, but I'm going to keep us going and hear at the outset from all of our speakers, and then we'll foster a conversation up here and eventually welcome questions from the audience. I'm going to ask Rebecca to go next. And Jen, I'm saving you for last. You're going to bring it home. So Rebecca Ingber is a law professor at Cardozo Law School in New York City and the co-director of the Florsheim Center for Constitutional Democracy. She is also a senior fellow at the Rice Center of Law and Security at the NYU School of Law. From 2021 to 2023, she served as counselor on international law in the Office of the Legal Advisor at the United States Department of State. She currently serves as the U.S. substitute member to the Council of Europe's Commission for Democracy. The Council of Europe's Commission for Democracy through Law. That's a very important part of the title, better known as the Venice Commission. We're very lucky to have her as well as all of our distinguished panelists. So, Rebecca.
All right, I might take this opportunity to stand.
Please.
Get my steps in. Okay. Also because it's after lunch. Well, first I just want to thank the conference organizers. This has been an incredible conference, so thanks so much to Mike and Morgan for making this happen and to Amanda for moderating this panel and my fellow panelists. I think putting aside the impetus for this conference, it really is great to be here discussing these issues with all of you. So I think the bureaucracy people sometimes feel like the neglected stepchildren at these conferences about presidential power. We're not even on the on the slide. We're after lunch. People are tired. But we know that this is, in fact, where at least 107% of the actual work of the presidency really happens. And in fact, yesterday, Pam Carlin referenced the work of Darrell Levinson and Rick Pildes and others declaring the end of the Madisonian separation of powers, or the Madisonian ideal of each branch protecting its own. And that paper, I think, is plainly right in many respects. But I have a friendly amendment, which is that it's my view that the entrenched bureaucracy, by which I don't just mean the civil servants, but all the actors within the executive branch who tend to survive the political players from administration to administration, this entrenched bureaucracy may well be the true inheritor of at least the executive's part in that Madisonian ideal. These bureaucrats are the very players who, despite being created and funded and protected by Congress, very much consider themselves creatures of the executive. They put the institution of the executive first, and over time, they are the ones who seek to expand and entrench and protect the executive's power. And as a result, it may not be all of the well-trodden reasons that we like to point to for the president's relative speed or efficiency or secrecy that give him a leg up vis-a-vis Congress, but rather the thousands serving in the entrenched bureaucracy who constantly monitor that boundary. But this is about aggrandizing executive power as a whole, and that's about the presidency. What about the president himself, the person of the president? because the bureaucracy may expand and protect presidential power, but it also can and does constrain presidents. Now, one of the things that I've found, and I'm glad Chris opened with a suggestion that we think about what bureaucratic resistance means, because one of the things that I've found when having these conversations that people are often talking past each other, because what they have in mind by bureaucratic resistance really varies dramatically. So I do think there's useful work to be done in creating sort of a typology about that. And I'll briefly touch on it, but I have more in the article that Chris mentioned. And on the one hand, we have those who paint any bureaucratic frustration of the president's will as the work of a quote-unquote deep state, some cabal conspiracy that's seeking to thwart the elected president. And under that rhetoric, any bureaucratic constraint on the president is illegitimate. On the other hand, we've got the zealous defenders of the bureaucracy, what we can refer to as sort of the hashtag resistance movement that you might recall from the Trump years. And that movement is going to be particularly present when we're talking about people who are not necessarily enamored of the sitting president, obviously. And in my own work, I've referred to these two approaches as the deep state approach and the benevolent constraints approaches. And these two narratives for thinking about the executive branch bureaucracy track longstanding debates in academia about the legitimacy of the administrative state as a whole. Now, of course, to borrow from something that Michael said yesterday, people's views of bureaucratic constraints are going to vary considerably depending on their view of the sitting president. And so I want to try to plot out some neutral principles about all of this. And I think that both of these approaches tend to both overstate and understate some really critical things. They overstate the polarity, the bipolarity of the executive branch. They overstate what resistance often looks like in practice. They overstate how much effective practical ability bureaucrats actually have to resist. What I'll call their functional power to resist, and they understate their formal power. They understate the formal authority that bureaucrats have to act, and as a result, they may dismiss the legitimacy of that resistance. So I'll go through each of these very briefly in turn. So first, what do I mean by saying that they overstate the bipolarity of the executive branch? Well, they paint the dynamic of bureaucratic resistance as if there is this stark dichotomy between the civil service on the one hand and the sitting president on the other. And that divide, in fact, is not actually where most of the tension occurs in the executive branch. For anyone who's worked inside the executive branch, I think you'll find familiar that most bureaucrats tend to clash regularly with other bureaucratic actors, often in a sort of horizontal way, with their lateral counterparts at other agencies or in other offices. And most of those tensions are longstanding. They survive from presidency to presidency. You could almost think of the entrenched bureaucracy as akin to sort of immortals sniffing at the passing whims of the mortal, short-lived political administration. And the leanings of any given temporary political administration may give one side or another a leg up in those interagency debates, but the real battle is still remaining between these entrenched immortals who will long outlive the presidents. There are also multiple axes along which the bureaucracy divides, and the career political one is just one of those. I'll just offer one example. One important divide that you might want to consider when you're thinking about the legitimacy of bureaucratic restraint is taint from partisan politics, right, or perceived taint, and I'm using taint for lack of a more neutral word. And this is a spectrum also rather than a crisp dichotomy. It doesn't map perfectly onto the civil servant political appointee divide. If you think about DOJ, for example, under longstanding norms, the Attorney General and the political appointees there are supposed to have some sort of buffer from the White House politics. And of course, we just talked about this during our lunch talk, at least for prosecutorial decisions, right? Jack said we should leave this in the hands of the Attorney General. He didn't say we should leave this in the hands of the President. Because there is a longstanding norm that the president is supposed to somehow be buffered from these kinds of prosecutorial decisions, even though, of course, the Attorney General is a political appointee and is by no means a civil servant. And on the other hand, you've got career civil servants from agencies who get detailed over to the White House and are much closer to the politics and energy of the White House inner circle and are expected to be able to see things from a White House lens. So the bureaucracy is a web of actors. It's not just a crisp dichotomy. I think these accounts also overstate what resistance looks like in practice. And Chris touched on this, so I won't dwell. But resistance typically takes the form of doing things that are quite within the realm of sort of lawful activities. asking questions, pushing back on ideas, dissenting in a meeting, refusing to change a legal analysis to suit political goals, refusing to change facts to suit political goals, putting things in an email, maybe taking the very extreme act of writing a memo to the file. And we can map out, I think, in terms of thinking about the typology, we can map out what resistance looks like along sort of a spectrum from resistance that is actually required by law to not necessarily required but authorized by law, like whistleblower resistance, right, to resistance that is not authorized but not illegal, right, that gray area, and then to resistance that is in fact illegal, right? And so we can think about legitimacy on those terms. And I would suggest that if you actually dig into most public accounts of really interesting episodes of bureaucratic resistance, you're not going to find many that fit into that last category. I certainly did not. So often what might feel to a president or to the outside world like deep state pushback is in fact just the neutral friction of the large bureaucracy that does not shift course on a dime or on a tweet or intuit the president's desires without those demands being translated down through the org chart. And relatedly, both of those accounts, the deep state and the hashtag resistance accounts, overstate how much practical effect bureaucrats can have in moving the ship of state. So both accounts assume that bureaucrats actually wield real power to constrain the president when he wants to act and maybe even seize the reins themselves. But the reality of much bureaucratic life is that most people inside the executive, from the president to the line official, feel often pretty hemmed in by all sides most of the time. They're hemmed in by the horizontal resistance that I've discussed. They're hemmed in by professional norms. They're hemmed in by their superiors up their chain and their inferiors down the chain. And they're hemmed in by their counterparts at other agencies. And they also face external constraints. They face judges asking them, have you checked with your political superiors before filing this brief? They face foreign counterparts wanting to know what their politically appointed bosses think before they suggest something. They face pushback from the courts and Congress. And so at least the president is not alone in feeling frustrated. But it's not because there's someone else at the helm steering the ship. Finally, I think the deep state account in particular understates the legitimacy of bureaucrats to resist, and specifically how much formal authority bureaucrats actually wield to constrain the president. So individuals throughout the bureaucracy, from political appointees down to civil servants, actually have a lot of legal authority, as I suggested, to engage in the kinds of actions that I would term resistance, even if they don't necessarily have a lot of practical power to change the direction of the ship. And this formal authority comes from lots of democratically accountable sources. It comes from congressional delegations. It comes from congressional protections. It comes also from judicial doctrines that allocate power. And a lot of their power comes from the president himself, both the sitting president and from past presidents, through subdelegations and through norms that survive from one presidency to the next, like, for example, the norm of DOJ and FBI independence from the White House. And the result of all of that is that bureaucrats have a lot of formal power, probably much more, than they are functionally capable of deploying. And this power includes the power to resist in the ways that I've mentioned. Okay, well, so these approaches that I've laid out to thinking about bureaucratic resistance are more than merely wrong. I think they're also dangerous. And they're dangerous because these narratives risk unsettling both the delicate balance of power inside the executive branch, as well as the checks from the other branches. So in stoking fears of the bureaucracy, for example, those who push the deep state rhetoric, as Chris was suggesting, might influence lawmakers and judges to erode the protections of the civil service, to cease to rely on their fact-finding authority, and to wear down the buffers and norms of their independence. And the courts and Congress need those actors. They need them because there are areas where they cannot tread. They are their eyes and their ears and their arms inside the bureaucracy, but this resulting erosion from this rhetoric hinders the ability of the bureaucracy to actually serve as that check on the president on their behalf. And it also can create a division between them. Instead of thinking that you're working for or with Congress, you see yourself as working against. There's also a risk in over-reliance on bureaucratic constraints, and that can lead to an abdication of responsibility, which is what we talked about at lunch, by actors like Congress when we need them to engage, because the bureaucracy cannot do everything, and it certainly can't do it alone. So to give one example for both, the Trump administration and its allies in Congress used fear of the bureaucracy, and in particular of the national security bureaucracy, to undermine the legitimacy of the law enforcement and intelligence agencies, specifically because he saw them as a threat. And in doing so, he eroded their ability to check abuses of power. But simultaneously, many in Congress, including within the president's own party, were relying on the existence of those same bureaucratic checks as a means of avoiding having to do the work themselves. So, for example, when asked, what are you doing to investigate Russian interference in our elections or corruption within the administration, these members of Congress could just point to the bureaucracy and say, let's let Bob Mueller do his job. And so over-reliance upon that office, or as Jack pointed out today at lunch, upon the idea of an ongoing investigation, allowed members of Congress to abdicate their own proper oversight functions. And even after January 6th, while the blood was still on the floor of the Capitol, congressional leadership decided to forego, Democratic leadership decided to forego immediate impeachment hearings and instead put their hope in then-President Trump's cabinet's bureaucratic resistance, in the idea that they would somehow invoke the 25th Amendment, and decided to push off the impeachment hearings as a result. Now, at times, there is no choice but to rely on the bureaucracy, and the most bone-chilling piece of January 6th for me is that despite the drumbeat of concern in the months prior over the possibility of the military interfering in our elections at the time, we ultimately required that the military step in order to secure the Capitol and permit that process to proceed, in contravention of the spirit of their commander-in-chief's desires, if not his direct orders. And frankly, we got so lucky. Because if Trump had issued a direct order to the contrary, I think it's fair to say that constitutional crisis would be an understatement. So miraculously, the bureaucracy was able to function within its legitimate and legal role to secure our institutions and process from the president. So given the complexity of modern government, I think it's fair to say that the courts in Congress need to lean on the bureaucracy to help them check the president, and the bureaucracy requires the support of all three branches to act with legitimacy. And fear and over-reliance risk upsetting that balance. But to the extent the bureaucracy may save us from the president, they're going to do so by continuing to function, by keeping the lights on until they're directly ordered to turn them off, not by taking the reins themselves.
So lots of great things to chew on there. Thank you so much. We're now going to hear from our final panelist, and that is Jennifer Mascott. She is a professor at the Scalia Law School and the co-director of the C. Boyden Gray Center for the Study of the Administrative State. She's formerly a Deputy Assistant Attorney General in the Office of Legal Counsel at the Department of Justice and an Associate Deputy Attorney General. She's also a public member of the Administrative Conference of the United States, and before all that, she served as a law clerk at the Supreme Court to Justice Thomas, and before that, then Judge Kavanaugh. Now, this is the bio that I asked. I asked each of the panelists, send me the bio you would like me to read, and this is what she sent. And I'm a little bit upset that she left out what I think is the most important aspect of her bio, namely that she took federal courts from me. She was my student many years ago, and I've just been delighted to see where her career has gone. So without further ado, we will hear from Professor Mascott.
Well, I was going to save that for my opening remarks, but Amanda she's amazing. I had her, I believe the first semester that you taught, and so it was a very special class, and she was obviously brilliant, but also just incredibly kind and immediately engaged with students and jumped right in at GW Law School. And we've remained friends over the years. And I consider her a great mentor and actually feel honored and humbled to be on the panel with you and everybody else. So it's a delight to be here. Michael, to Chris's point, bringing together a great group. So, I kind of like to stir the pot sometimes at these things. And it's, a Saturday afternoon and we're here in Palo Alto, so let's go. So the first... the first thing, really, at the end of the day, I don't think what I'm saying is all that controversial, but we can pretend. So the idea, just empirically, about what Chris was saying about the the Trump administration being somewhat forward-leaning with the idea of the unitary executive. Perhaps that's true at the end with the Schedule F. What he's referring to is actually trying to use statutory authority to recategorize people who had a certain level of authority to where they could be more easily fired. But what's somewhat intriguing and perhaps a lesson maybe to future administrations if they want to get things done and they think it's by putting their people in place is that arguably, it wasn't really all that reported on maybe because there were other things going on in the news, but actually the Biden administration took quite a few steps in terms of getting rid of a lot of the people they could who had honorific commissions and getting rid of folks who had been traditionally seen as holdovers like general counsels in various entities like I believe the NLRB, and actually in a more perhaps fulsome way use constitutional and statutory authority to get rid of people. And what might be striking, especially since we're sitting here and talking about kind of the worst case scenarios of bureaucratic resistance and is the Supreme Court going to undermine independence and everything, but presidents, I think on both sides, don't actually necessarily fully use all of the power that they currently have in place under statutes to supervise and get rid of people because, for example, even in the civil service context, you can remove people for cause. A lot of times with commissioners at the head of multi-member agencies, technically there's for cause. And we don't really in our system have a good sense of what exactly cause means. We don't do the test case, I think because there are so many political consequences sometimes to using these powers and because multiple decision makers have to come together and coalesce and get around it. So all of those things lead me to believe that I think the category and the idea of bureaucratic resistance is a very intriguing discussion. I have to say I'm going to fight the title of the panel a little bit and say I think it's somewhat of an overblown concept and idea, having worked in the executive branch, and then I also don't think it's actually a meaningful constitutional category, and so I'll explain why. So I was at the Office of Legal Counsel as a deputy, so a step below where Jack Goldsmith was, and then a couple of administrations later. And the first thing I should say is I just found it to be immensely enjoyable all the way down the line at DOJ, working with everyone, career servants, bureaucrats, political appointees. I mean, things got a little crazy at the end, which I'll touch on. But the New York Times has already made it all public, so there's no confidentiality violations. But it's really just an amazing resource and treasure of excellent lawyers who are committed to doing a good job, who are smart, who work together, who are kind, I still have friendly relationships with civil servants who were there. So at least in Department of Justice, it's not as though there's this big groundswell that you might think of people who are chafing to fight against and resist. I mean, there is the phenomenon of sometimes attorneys not wanting to join certain briefs, and I think the Department of Justice has a custom, like it has some of the other customs and norms that Jack was sometimes implicitly referencing in his remarks, of sometimes not requiring people to sign briefs if they really morally disagree with it, because there are so many attorneys there. The other thing that sometimes I think gets lost, resistance may not necessarily always be a flat out, I'm not going to sign this, or I'm going to resign, or I'm going to oppose you, but it could even be not vigorously carrying out one's duties or using one's resources to effectuate what the supervisor or the president has wanted you to do. So I'm sure that happens. But at the end of the day, what's interesting to think about from a constitutional structural standpoint is that I found the more notable phenomenon to be the continuity in legal views and in norms and in interests pushing across administrations. And the executive branch lawyer these days, at least at DOJ, seem to me to mostly be focused consistently on executive branch and presidential prerogatives. And there's striking similarity. If you look at the presidential interest in protecting power and effectuating what the president wants to do as a policy matter in terms of not letting Congress encroach in the area of foreign affairs or national security, you have tens of thousands of lawyers who are in that branch of the government who are all their job, in a sense, is to protect those prerogatives. And so for people who are concerned about concentration of power or federal power, it's actually quite alarming that there is so much continuity of people who are all aligned around the interest of supporting and furthering the president or the power of one actor in our constitutional structure. And so perhaps regardless of our view about bureaucratic resistance, there might be a lot of folks who should or would want to spend time thinking about how we can beef up some of the other branches of government. So I actually think there's a bigger problem with the executive continuity, in a sense, than bureaucratic resistance. Why would I say it's not really a meaningful constitutional category? And this is, I guess, where I'm getting somewhat formalistic, and also maybe where, to Rebecca's point, definitions would come in. Because I think if you're an executive branch lawyer, you have several options. One, you can serve the president, fulfill your constitutional oath, carry out what the president's told you to do. What if you believe that that is something that's unlawful or wrong or immoral? Well, you could step down. Or I do think it's meaningful and entirely appropriate, and lots of time should be spent on trying to persuade the supervisors or the president or whoever it is to do the right thing. So there can be that middle road, let's try to figure out the right answer, why are we being told to do X? And so maybe that's what we mean by resistance. Certainly it is completely appropriate within the bounds of being asked to advise and move the ball forward to be able to fully vet ideas. But if we're getting to the point where we're talking about secrecy or dishonesty or actually being told no and then trying to work from within against the agenda, at that point, that's where I would say I don't see how that could really be consistent with the constitutional oath. It's a little bit tricky because I also think there hasn't been much theorizing done about precisely who the executive branch lawyer is supposed to be serving. And there could be many different entities or people. One, obviously everybody in the government takes an oath to the Constitution. Well, the Constitution has many different parts. So if you're in the executive branch, are you taking an oath to further executive power, to help the president, to the Constitution in general, to the people, to liberty? Do you have your own moral compass? And I think it's that last point that's probably where I would get most concerned if your view is that every power source needs accountability. At the end of the day, if you truly see civil servants as needing to be independent, the question arises, who will then keep them accountable? And you start to lose that electoral connection. So one final point just about the whole ability to be able to persuade from within. I think if you, and I'm just here going to talk only in high levels about public reporting. I actually had literally zero role in any of this, but one of the most salacious or controversial examples of bureaucratic resistance or whatever in the Trump administration, people like to talk about at the end, right? With leading up to January 6th, and then at the Department of Justice, if you believe the New York Times suggests that there was almost an attempted coup of like an official who wanted to further promote fraud claims and try to get himself appointed as Attorney General. And just assuming the facts as the New York Times reported them, if that's indeed correct, I mean, that is not, I don't think the idea I'm talking about with the unitary executive and having to fulfill one's oath to serve the president or the Constitution needs to be scary in the sense that that oath has to be consistent with constitutional principles. So in that scenario, I don't actually think that the individual who is trying to have the most forward-leaning view of fraud claims and protect the president's reelection and all of that is the one who is actually properly carrying out the unitary executive role, right? Because if everybody has to be faithful to take care that the laws be faithfully executed, that means the president, it means the staff, everybody has to be working toward that end. So to the extent that there's somebody out here who's trying to sort of usurp that and do what they perceive as better in the interest of the president, that's not actually in an appropriate part of the constitutional structure either. And if you believe the reports, the response of the other folks to sit there and to, discuss and persuade and ultimately prevail and not have that coup or whatever it was going to be occur, it suggests that at least in that snapshot of time, that the discussion and the working with the president was successful and the president remained faithful to the Constitution and the people helping to persuade him were subordinate and the person who was out here bucking the system was actually on the wrong track. So that, I think there can be, I don't think it's always an easy thing to unpiece whose loyalties should lie where and how the constitutional oath versus executive power and everything fall out, except that the idea of just individual independence cannot possibly coexist in our constitutional system because there's literally no spot in the Constitution where there has ever been authority for individuals to go around and exercise power on their own. It always has to be accountable back to the electorate and as part of a multiple decision-making multiple actor decision-making process. So on that note, I'm sure everybody will disagree, but it's fine.
So I have a million things I want to ask our brilliant panelists, but I actually, before I do that, I thought I would ask if any of you wanted to respond to anything that your fellow panelists may have said.
I think the only thought I kept on having, and this might get back to Santiago, like where we started, is I'm still myopically focused on lawyers as civil servants, and I wonder, it's such a law school thing to do, right? But along the axis you were talking about, another way I think you might distinguish is lawyers versus non-lawyers, and of course non-lawyers fall into many different categories of programmatic and other types of experts. And I wonder if, when we think about bureaucratic resistance, we should be thinking a little bit more nuanced about that.
Yeah, I'll respond to that a little bit. I do often, as a lawyer and as a government lawyer previously, tend to think a lot about lawyers. I think that lawyers have, when we think about the tools or the formal authority that different actors have to resist, different sets of actors have different tools. So actors who are focused on scientific research will have, I'm not going to manipulate the facts, right? And I think that lawyers have the equivalent when it comes to law. That's their version of not manipulating the facts. They're not going to manipulate the law. As we know, and this may well be true for scientists also. I'm just not a scientist, but and the scientists in the in the room can tell us. But as we know, for lawyers, there's going to be room for gray. But that does the I'm not going to do something illegal gives them that power, gives them that formal authority that a non-lawyer might not have as easily, but they're going to have other sources.
Did you want to say anything on that?
I don't think I have much to say. Certainly people have talked about this issue of bureaucratic resistance in a context that is way broader than lawyers, I would say. In the study that we look at, some people are lawyers, but many are not lawyers, and I think that I think coming from a perspective, I'm certainly not coming from the perspective of a lawyer, but I do think that in many settings beyond being a lawyer, there are also gray areas that people can exploit to their favor. I'm an economist, and you could certainly, if you're asked to write a prediction, there's a gray area of where what could be an acceptable forecast, and I don't think that that's exclusive to the law, to the profession.
Right, and as you're all speaking, I'm thinking of COVID in that period and how the bureaucracy functioned in dealing with the hard scientific questions of that period. I do have to say, I was so pleased to hear you talk about Postal Service employees for two reasons. One, it made me think of my dear former colleague who's now here, who is obsessed with the Postal Service. She would have loved your talk, and Joseph O'Connell. And secondly, my grandfather was a letter carrier, so I liked that. More generally, I'll start with one of my questions, and it's something that I've long thought about and struggled with how to think about, and with all of you on this panel, I want to hear what you think. Some of you have touched on this. In fact, most of you have touched on this, and this is this sort of question of how we foster a professionalized civil service with norms and culture that emphasize professionalism. And we can bring the oath into that conversation as well. I think it's so important to thinking about these questions. How does one think about that on the one hand, and accountability, preserving accountability within the executive branch, which seems to me to be the meta question here, one of a few meta questions. And I think a subsidiary question to that is, are those two necessarily at odds? And I hear Jen to offer an example, and I think there are others as well from the administration in question that you're describing, of where you have individuals who are not part of a professionalized, tenured civil service regime who are actually throwing up guardrails. And that suggests that maybe, now this is one administration, one set of examples, but it does suggest that maybe political accountability or accountability within the executive branch is not obviously at odds with the idea of having a professionalized civil service. And so I'd be curious to hear some of your reactions to that. Anyone?
You want? So yeah, I mean, I think this is a great question. And I've thought a lot about this question in the agency adjudication context. So with the administrative law judge and other agency adjudicators, Melissa Wasserman, Aaron Nilsson and I have a new paper where we kind of say, like, when we think about accountability, we're really mixing two different concepts, policy and personnel. And I think the Supreme Court has really messed up in mixing the concepts of hiring and firing versus policy control. And in the paper, we say, when the Administrative Procedure Act was enacted, the Congress envisioned a model of agency adjudication that actually struck the right balance, in my mind, of control. They said that the trial level adjudicator, the administrative law judge, would have decisional independence, would be hired based on merit, could only be fired based on merit, and would make the decision, find the facts, and apply the law without political interference. And without the fear of being fired or demoted or even getting raises or promoted based on doing what the agency head would want them to do. And then the agency head, though, has final decision-making authority. So politics does play a role in agency adjudication, but it doesn't play a role in creating the record and finding the facts and and allowing for the public and Congress and courts to review what the political head does on that front. And I think you could take that standard model of agency adjudication for the Administrative Procedure Act and project it across the career civil service as well in a lot of different contexts of saying, those folks that are the career civil service that are finding the facts, that are doing the research, that are doing the legal analysis, we want them to be able to do that in as impartial a way as possible, which requires them that they be hired based on merit and not politics, and they have a certain level of tenure protection and professional norms. But we have to recognize that ultimately there's a political head that can override them. And then it goes to the court and the court of public opinion and to Congress on whether we think that overriding based on politics is right as a matter of policy or, quite frankly, even right as a matter of law. So I think that's the balance. And I think the court in a case called United States versus Arthrex understood and struck that balance really well when administrative law judges, administrative patent judges were trying to figure out whether they're unconstitutional or not because they weren't, long story. They had two paths to make it constitutionally correct. I'm actually not sure either makes, but that's a different panel. One was to just remove their tenure protections entirely, and those judges could be fired at will by the head of the U.S. Patent and Trademark Office. The other was to give the head of the office final decision-making authority. The Federal Circuit did the former, and a lot of us were like, that's like the worst possible thing you could do if you're trying to preserve kind of independence of adjudication. And Chief Justice Roberts for the Supreme Court, the majority adopted the latter. And I really do think that is what needs to be captured is this idea that accountability is not, people say personnel is policy, and that's true. But in this context, it's not. They are two separate concepts of control. And the way to strike that right balance is to have policy control, but not personnel control of the lower level fact finders. Sorry, that was a long answer, but this is a paper I really love and I'm excited about. So. And Aaron and I are basically writing the same paper now, but about the civil service, kind of extending that into the civil service.
Jen?
Well, I totally agree with that. I think actually the way in which administrations implemented the Lucia decision, where the Supreme Court said that agency adjudicators, some of them are officers, is a good indicator where essentially now agency adjudicators at a high level had to be appointed by the president or the president with Senate consent or a department head because they were inferior officers. And the way in which agencies tried to implement it was actually still in many cases merit-based. So for example, the Department of Labor had a set of procedures that it put in place where the Secretary of Labor was ultimately going to be able to sign off and had to sign off from one of among three candidates. And if he didn't like any of them, he could just have the process start over. But the whole process was to have various little boards and panels and people in place evaluating based on merit. And if you look at the Article 2 provision that talks about appointments clause and officers, where a lot of these doctrines originate, it refers to Congress establishing offices by law. And so certainly in that power, Congress can make certain decisions about which offices need to be in existence, how much the office is going to get paid, what the duties are going to be, and perhaps different merit-based considerations, so long as they're not actually filling the office with taking the president's nomination role. And then, of course, Congress could obviously use merit-based considerations when they decide in the PAS positions how they're going to exercise their consent authority. So I actually think the two were probably intentionally, originally designed to coexist based on the way in which the drafters and ratifiers of the Constitution would discuss staffing the government.
I'm going to throw out one more question, and then I'll open it up to the audience, even though I have more. So I'm having to, I'm thinking of the scene in what, it's not Raiders of the Lost Ark, but whatever the third iteration is, where the old knight says, choose wisely. I'm having to choose wisely what I ask. And I'm going to recycle a question, actually, from the last panel, because it's one that I think about constantly today when we think about separation of powers questions writ large, and that is, this is a question that Professor Sklansky put to his panel. How do we think about some of the questions that we're debating in light of present circumstances? In other words, when we think about the state of our government, we think about the high politicization of the times in which we live. Should that influence how we think about questions of professionalization, questions of tenure protection, questions of how much we want to encourage, for example, to borrow the title of this panel, internal executive branch resistance? When we think about, for example, the state of Congress and the state of congressional oversight, should that influence how we think about these questions? We had answers from some of the last panelists. I'd be curious if any of you have reactions to that question as it applies to our set of issues.
I'll take a very quick answer, which is that I actually think that members of Congress think about it, and I think that what we saw, for example, during the Trump administration with like 702 reauthorization, so intelligence agency authorities, which members of, I think, both parties were somewhat reticent to place in the hands of the Trump administration itself. And I think that they were only willing to do so and reauthorize on the basis of their understanding that those authorities would be wielded by the very bureaucrats that they were publicly denigrating as the deep state, right? They were publicly denigrating them as the deep state, but in reality, voting to reauthorize in reliance on the idea that they were not actually, like a Hoover-era deep state that was going to be using these authorities, but rather people that they trusted. And so there was this really sharp contrast, I think, between what you could get, if we can think that their votes meant anything, between what they seemed to really believe with their votes and the rhetoric that they were willing to engage in. And so my concern is that rhetoric over time, your constituents listen, they buy it, and over time, you will start to believe it yourself, or they will believe it sufficiently that they will elect people who believe it. And so, and you will no longer have either that sort of special dynamic where members of Congress can vote for something in reliance on it being undertaken by the professional actors inside the executive branch will cease to be possible.
Anyone want to add to that?
I would just say, the hydraulics we're seeing of administrative law playing such a more, it's become politicized too, right?
Highly politicized.
I blame all the common law professors that couldn't get jobs as common law professors and became administrative law professors in part. But the reality is I think presidents are doing a lot on their own now. They always have, but it feels more tangible, and they need bureaucracy to make it work. And I think neutral principles in administrative law that were very, very popular for decades, we need to keep those, and I think one of those is a professionalized civil service.
Michael.
When I think about the entrenched bureaucracy, I think that a lot of the problem may be its political skew. Maybe I'm wrong about this, but it seems to me I've seen, polling data of employees in Washington and so forth, and certainly I think there's a lot of popular perception that that the bureaucracy is overwhelmingly populated with people from one party. Now, different agencies have a slightly different skew.
Very different skew.
Defense Department might be a little more, Republican-oriented and so forth. So I don't want to make huge generalizations, but I'm inclined to think that that a professional bureaucracy would do a better job if it were more diverse, and diversity meaning in terms of ideology, really more than anything else. And is there any way to get more diversity into the bureaucracy without sacrificing professionalism?
I have one small thing. So on the first point that you raised, I mean, I think certainly the case. So there's a very recent paper that looks at the political composition of the federal bureaucracy, where what they did was to match data on federal personnel to voter registration files, and this pattern of bureaucrats being overwhelming Democrats is certainly true in the data. You do see that this bounces a little bit when there is a change in who is the president, but even during Republican presidencies, most bureaucrats are Democrats. So this is certainly an empirical thing of the last decades or so.
Can I
Yeah.
jump in on this too?
Yeah.
So I mean, over like 4 or 5 different studies I've done, I've probably interviewed about 400 or 500 lawyers that work at agencies, and they're pretty moderate. I mean, I agree, they're center-left Democrats, but they're kind of law nerd technocrats. I think they're kind of, I don't love the idea of having a lot, I don't know, I mean, I kind of want like the median like a lawyer. But I do think one issue with attacking, with my side of the aisle attacking the administrative state, in the deep state, how we want to call it, is it makes it a lot less attractive for someone like me who grew up in a Republican family, went to the Kennedy School of Government, thought I'd serve in government, did serve in government. Like those folks that are center-right or right, when we ruin the kind of idea that it's a professionalized civil service, you're really just really encouraging folks that are on the right from even thinking about discouraging of doing doing public service. And I worry about that. I don't know how to fix that, but I worry about that. But at least when it comes to lawyers, I don't feel like the story of a bunch of left-wing crazies kind of running. I do think you're right, though, with respect to other programmatic areas at certain agencies. It's certainly true that they're at least very mission-driven in their approach.
Although I wonder if empirically, like, if there's ever been any work done to figure out if everybody's in the middle, is that better and more middle of the road, or do you get a more multi-textured, cohesive, like, view if there's people all along the spectrum? So that's just one observation. But the other thing is, even if they're moderates in DC, it's still just an urban city. So actually, David Fontana, I believe it was, from GW, started writing about what if we dispersed folks regionally and put them out like all around the country in different places and offices, because at least there you'd have geographical diversity, regional interests, presumably there'd be political differences in play. So that may be one. I mean, it'd be expensive because you have to decentralize like all of this agency offices, but I struggle to see how it could be bad.
Yeah, I think that's a really interesting idea. I would just add that I think the most predominant feature, this is anecdotal, but it is more, and this goes to what Chris said, is that people choose their agencies, and so they're mission driven, right? What you will find is that people who go to the State Department have certain proclivities. People who go to DOD, people who choose to work for ICE are going to be different than people who go to work for the EPA. And so that is a much more predominant feature of who these people are, and is part of why I say that the clashes between the agencies are actually where most of the action happens and most of the tension happens, as opposed to clashes between the civil servants and the sort of political overseers.
Can I push back on that? I'm not even sure I'm pushing back on it, but lawyers, though, actually don't map, at least in my experience, having interviewed lawyers at probably every executive branch agency, like 10, they actually don't map onto that very well, like the mission-driven part. Like,
You don't think lawyers choose DOD versus
so
state
like
based on
rulemaking lawyers, they go all over the place. If you follow their careers, they bounce around agencies, civic matters. I don't, with lawyers, at least again, it's impressionistic. I didn't interview them on this. I interviewed them on other
Yeah.
stuff, right? But it was just my impression that they kind of view themselves as regulators or enforcement and not as like EPA lawyers.
Well, that's
first. But
similar,
I could be wrong.
but-
But I think programmatically, I think you're right.
Yeah. I mean, I certainly, the Office of the Legal Advisor of the State Department is full of career people who spend their entire careers there.
Yeah, state's a little bit
DOD's similar.
Is this the general
The
counsel's
LC.
office? Could the GC's office be different from the?
Yes,
Yeah.
yeah, absolutely.
Okay.
Yeah,
So,
people about
I'm,
GCL.
yeah, I'm not thinking about people who bounce around, but certainly if someone's going to bounce around, they're gonna have less of a mission-driven focus. Yeah, and certainly people who go and spend their careers as non-lawyers in these agencies are going to be doing so for a reason.
Please.
Thank you. So my name is Ethan. Thank you very much for the discussion. I have a question to follow up on a point that Jennifer made, but in full disclosure, I'm a libertarian, so I am anti-bureaucratic state. And here is the question, but I hope. So I think that those who believe in the bureaucracy and the resistance are building a false premise, which is that you can equate virtue or ethics with professional competence. And I don't know if there is a study about that. I can tell you about my experience. I got a PhD from these institutions in electrical engineering. I met very bright people. I work in high tech. I met very, very bright people. And I see that those qualities are completely orthogonal, that you cannot infer virtue ethics from just pure professional. And I don't know if there is a study. And I'm going to illustrate that with an example from this institution. In 2020, the faculty senate of this institution censored Scott Atlas because he was working with Trump, right? That decision has not aged well. In fact, they are trying to undo the censor vote. I mean, they're now talking about that. And that's a prime example of this notion that you can, the medical school wrote a letter against him, and it was very much politically motivated. So this notion that you can equate competence with virtue ethics, I think is a false premise. And every experiment in history, whether it's the Soviet Union, which is built on the premise communism, is the notion that you can put experts in charge and everything works fine. But that is not true. And China is the same thing. So those of you who defend the virtue of the bureaucrat, I would like to see whether you have something else to say about that.
No, I think that's an excellent point. I mean, historically, or at least now, the modern tendency is to see experience as being distinct from this idea of just hiring your political crony friends. But of course, that's, I mean, but you raise a good point that there are many different factors going on, and that having experience doesn't necessarily mean even you're going to apply that experience to your job. And of course, everybody's making small p political choices all the time, and there isn't necessarily a character test for government service. So I think also folks would tend to resist the notion that you want bureaucracy because it can be efficient. Because sometimes we think about, let's get the administrative state doing it because Congress is inefficient or courts are inefficient, and then you look at people who have been in agency adjudicative processes for years. And so I think there could stand to be work done on empirically testing some of these assumptions we have. So that's a good point. Anybody else?
Next question, please.
So I was curious about how to think about the role of outside social and employment networks in sustaining or sometimes discouraging or sometimes accelerating kind of internal bureaucratic resistance. I guess in particular, I'm thinking that at least if people are going to take a significant risk in resisting some policy or sometimes even carrying out a policy, they're going to know that they'll still have friends and they'll still have outside employment opportunities. And I guess I would think at its best that those kind of networks ensure kind of competent professional judgments within agencies. You know, at its worst, it's something like regulatory capture. And I guess I'm a little worried that as everything in our society seems to get politicized, you might get some kind of bad network effects that way. But I'm just curious about whether folks in the panel agree that's an important part of the equation, how to think about the interface between those outside influences and the kind of internal legal structures you're talking about.
Yeah, so I mean, I take the question to be how much of a check is that on government actors? What do you all think?
Yeah, that's a smart question. I don't know if I'm smart enough to pull that one off. I don't know. I mean, it's something that I don't even know how you would measure kind of. When you're talking, what immediately came to mind is like a hypothetical where a Supreme Court clerk leaked an opinion,
Yeah.
you know, and then took the credit later and was like paraded by either the conservatives or liberals, depending on your hypothetical world. I don't know. Do we see that? I'm just curious. Like, do we see outside groups that are kind of promoting the resistance? I mean, they're definitely some. I'm curious, Beck. I mean, your thought process.
Yeah, I mean, so I'll say, on the one hand, I actually think it goes the other way, which is that, you know, in the government, people talk about the Washington Post test, right, which is that it's not about whether or not you're taking an action that's legal, but rather if this were to show up on the front page of the Washington Post tomorrow, how would you feel about that, right? And so there is some implicit constraint in the idea that what you do may one day become public and you are going to be held accountable to your peers, to your social and professional networks, et cetera. And so, so I think that is a constraint, but I think you were asking if it can be a support, like a bolstering. And that's a harder question for me. I do think it's a constraint. I think it's a real constraint, and I think the higher up the people are within the executive, like the more likely they are to, sort of the political appointees are more likely to leave, and so they are going to be more likely to be sort of swayed by their outside communities, whereas the people who spend their careers inside the government, their professional networks are predominantly inside the government. And so there's some groupthink there and other factors as well. So I think, and this goes to something Amanda said earlier, the question, I just had an anecdotal response, which is that I think it's sort of built into the DNA of the professional civil service to sort of be a little bit lower key than the political appointee types. And so when you see the splashy kind of resistance that we saw during the Trump administration, every single time it was the higher level people who'd actually been part of his own cadre. And the neutral friction that I talk about is really what you see predominantly from the civil service. So I'm not sure that, but I don't know, I don't have an answer to your question about the support piece, because I think that for the civil service in particular, their support is coming from within, not from the outside.
Could be a really fun paper, though.
Yeah.
Well, when you were asking your question, what it made me think about is the higher levels who just say, yes, the ramifications are going to be troubling, I'm just getting out of here.
Yeah.
And that's not necessarily the response that we want. On that note, I'm going to call on Jack.
Okay. Yeah. I'm just wondering, I think someone mentioned this briefly, whether anyone has an informed view about the legality of Trump's proposal to make a bunch of people Schedule F and then fire them, and how broadly that might cut if done very aggressively, and whether the recent OPM rule is any break on that, and any of that stuff.
Well, I
I'm
don't know.
interested in the legal issues, but you can talk about anything you want.
I mean, I don't know about the recent OPM. I have to look at the recent OPM rule. I think that the Schedule F category was written to just make sure that it was looking at folks who fell within certain statutorily carved out categories of confidential or higher level employees. So it seemed to be statutorily sound. I mean, I don't actually know where we're getting the idea that he necessarily would then fire all those people. I think they were then just supposed to operate more like political appointees. But again, how frequently are political appointees in any administration being fired? Rarely. I mean, we didn't have that. I don't know, nobody running around DOJ that I was aware of was concerned they were going to be terminated because they didn't do their job, nor do I actually recall myself spending a ton of time when I was making decisions considering in any way whether it was going to get me fired. It was more like you're just sort of there and you're trying to effectuate and do the best job. I do think there were some lawyers who started wondering, and this I think was the category error. Some folks maybe who you would say, is there a due process thing where all of a sudden people thought they had tenure protections and then they don't? And if you look at classic administrative law doctrine, like with adjudication, individualized decisions versus rulemaking, and where due process rights kick in, I actually think there's zero due process concern because it was just a statutory category change across the board. And so you would simply have to make sure that people had some process to challenge whether they fell within a particular category, not the creation of the category itself. So I think it's honestly somewhat surprising and disturbing, whether it's that proposal or a proposal another president might have, that there was so much hand-wringing about effectuating it, because, I mean, if you're gonna govern, you should just govern and do what you think the electorate wants you to do, and maybe we're spending too much time procrastinating on some of these decisions, and not kind of getting on with the policy goal. Anyway.
In fact, do you have a take on this? No. I mean, Jack just wants the legal side. So, I mean, I think legal. I have not seen a great argument that it was not legal, that it was not within the statutory authority. I would disagree really strongly with Jen that being considered a political appointee as opposed to a career civil servant is the same thing. I mean, I think high-ranking civil servants chose that to not be political, and they definitely do not want to be in a political category where they could be fired by their agency head. I think it dramatically changes the civil service. That may or may not be a good thing. We can have a policy debate about it, but I mean, I do think it just dramatically changes your role when you get switched over in Schedule F to the accepted service.
All right, last question.
So this is sort of a DOJ-specific issue. and being somebody who's never been inside of it, sometimes you see briefs written, and occasionally sort of the inside baseball people will point out, oh, nobody from the career side signed this brief. And then it's sort of this signal, at least within the community, about how somehow it's some disagreement within the department or disagreement with what the political side is doing. I just wonder about what that signal is actually doing, apart from sort of internal struggles. And it's a little strange in a different sense, right? I can't imagine many places where people come in and say, hey, we're working on this project, and you say, well, I'm just not going to sign it. I don't know how that would work very long in the private sector, but there seems to be a sort of a culture at DOJ to be able to do that and have some sort of selectivity. So I'm just interested in that sort of demarcation about those briefs.
So I'll add to that, which is the practice of relevant interagency lawyers choosing not to sign briefs, which is very much a practice, right? So a brief that often a brief that is that deals with issues that a variety of agencies will have a stake in. The legal advisors or the general counsel of those agencies will sign the brief as well. They will be heavily involved in the process. And there have been times, and I've seen this happen, where an agency actually is opposed to the final product or wants to non-concur, and there's not a clear decision maker in that situation, except that when it's DOJ, when it's a brief, DOJ sort of holds the reins. If it was a different decision-making process, and I've written about this, if it's a different kind of decision-making process, if it was like a report going to a treaty body, a different actor, the State Department in that case would be holding the pen. So DOJ is holding the pen, they make the final decision, they're going to file the brief as is, and the legal advisor, let's say, or the general counsel of one of the agencies that says, I'm not signing that. And so the absence of someone who should be on that brief or who was on the last round of briefing and is no longer is a real signal. I also think that, and I've seen this happen at DOJ, but I think the people who worked at DOJ should speak to it, but I have seen situations where a line attorney really would rather not make an argument or join a brief, and the higher-ups, whether they be political actors or just higher-level career people who are running that office, will step in and say, I'll do it. And I don't see that as much, it's almost less resistance by the individual as it is a favor by the political actor or the higher level civil servant to say, listen, I know that this is not something you want to be out there on. I'm going to do it. I'll take this one because this is my job. I'm the political face, or I'm the head of this office. It's my job to take that for the team. If this is the argument we're going to make, it's not on you.
I mean, did you want to jump in?
I was just going to say, I don't think it actually should be taken necessarily as a signaling mechanism, because it's always very hard to know what goes on behind the scenes, and you're just making a ton of assumptions based on who would have signed the brief, who was assigned to what personal circumstances they have. It is tough to see how it would be appropriate for people just to drop off briefs because they don't want to be on them, in part because you're really just, again, operating as an agent of the government at that point. And if you're going to be in the job, you sort of have to be willing to do it. I suppose the one exception maybe you could think of that be different in kind is if as a lawyer there's a sanctionable thing, like you don't want to be signing something that you think is legally wrong. And if you can't persuade people it's legally wrong, but you still think you can maintain employment there, maybe then you have a real ethical thing. I think that's probably the rare case. If it were me, I honestly don't have a ton of visibility into it, because this is getting down into the minutia, I think, of how the individual litigating offices operate and who assigns which attorney to which case. And some of it's even just about how can we give people as many arguments as possible, and it's actually like a positive thing. But I would, if it were me managing it and being queen for a day, I would want there to be some very clear policies in place in advance, having very clear guidelines about when we as an administration or just a system think it's permissible for an individual not to sign a brief. And so everybody knows the rules of the road going in, so you don't have kind of the passions right within the conflict of a challenging case about what's going to be permissible or not.
Yeah, Derek, I was not on the inside during the Trump DOJ, but when I was at Civil Appellate, it was more, you didn't sign the brief because you chose not to work on it, right? And that happened all the time. That was the norm on the Civil Division side of, if there's something you didn't feel comfortable working on, whether, back in my day, that was Guantanamo Bay cases, you just didn't work on them. And that was just the norm among the civil servants. And there are some instances where no civil servant wants to work on something, and then the career has to do it themselves. And that happens. I mean, if you go look at Office of Immigration Litigation, you have a fun FOIA adventure of the times where there's not a career person on the briefs, and it's just because that administration's taken a position that they don't feel is consistent with their own beliefs. And so when I think of not name on the brief, I've always assumed that meant they didn't work on it at all. They refused to work on it. And refuse to work on it is within the norms of the Justice Department. Getting back to your category, it's allowed. I could imagine maybe in a different administration they don't allow that, and then you have that. That'd be interesting. But that definitely, I think, is still a norm within the Justice Department of not working on stuff that you don't feel comfortable working on.
I have to say, hearing all of these comments, I'm thinking that a lot of these issues are not new. They're making me think of a lot of the challenges that the Justice Department faced during World War II in confronting the Japanese American mass incarceration. But that's for another day.
You've written out a little on that.
Please join me in thanking our spectacular panelists. Michael, the floor is yours.
Thank you. Is this on? It's very late in the day, and it's a beautiful day, so I'm not going to delay things. Mostly, I'd just like to thank all the excellent speakers. I don't know how others reacted to this, but I thought it was what Robert Bork would have called an intellectual feast, right? And thanks also to the audience for your attentiveness and for all the excellent questions. And let me just say, I think it's really good advice to anyone entering into the job of the President of the United States. Just beware.